Michael Waslick. I'm here on behalf of Jennifer and Jason Lexell. And the issue before the court is a very narrow issue on review, whether the trial court erred in denying entitlement to costs when the plaintiff voluntarily dismissed its case. Your Honor,
it seems as though there's no disagreement that your client's entitled to what I'll call the little cost. There's still a dispute if we were to send this back, or is there a dispute as to whether attorney's fees are a matter of cost under the operable documents? Is that what's really going on?
I think that we agree that the entitlement to costs is something that the trial court erred on by denying. The bank's brief did not really address that issue.
Well, they agreed you're entitled to hard costs. I thought they agreed you're entitled to hard costs only.
They did say that, and the issue, however, is that under the Wilson case and the Fleet case, the definition of costs that are to be included after entitlement, when the court considers quantum, is part of the mortgage contract, paragraph 22 of the mortgage contract, which states that in this case, it states the lender shall be entitled to collect all expenses incurred in pursuing the remedies provided in section 22, i.e. foreclosure.
Well, let me ask you a question.
Yes.
Is the main beef here that the judge denied entitlement to fees, or is there some argument that the judge exercised discretion saying I'm denying attorney fees because these people may have consulted an attorney, but the case was voluntarily dismissed before the answer was filed, therefore there's really no legal work that was done connected to this case?
Well, if you look at the record, that's not what the trial court...
Oh, then elucidate me. That's why I'm asking the question.
If you look at the record, the record includes the transcript of the hearing, and the only argument advanced by the dismissing party in this case was that some extra record allegations of settlement, and which, again, there's no evidence of any settlement presented or anything like that.
So it was voluntarily dismissed. They claim pursuant to settlement, but you're disputing that was ever agreed to.
Well, what I'm suggesting, Your Honor, is that there was no evidence of settlement presented that would justify, in this case, a denial.
What I'm trying to figure out is judges presented with X, Y, Z.
Correct.
Usually, if an attorney says something, a judge will tend to believe it. Now, I understand it's not evidence when it's disputed, but if it's said in the mode of, hey, this case is settled, we're dismissing it, and then nobody objects, would there be a reason why the judge wouldn't accept that at face value?
Well, yes, Your Honor, and the reason that the trial court couldn't accept that at face value is the Valenti case we cite in our brief, and in this case, so it's an unsworn assertion of counsel. That objection was made on page 8 of the trial court transcript.
On the motion to dismiss.
At the hearing on entitlement.
Okay.
At the hearing on entitlement, the transcript that was supplemented to the record, pages 7 and 8 address that issue. Page 7 is the bank advancing this idea that there's a settlement agreement. Page 8
okay, so you're referring to the hearing that occurred within 30 days following the voluntary dismissal?
Correct, the hearing on entitlement.
And there was never a hearing on the bank's, quote, notice of voluntary dismissal. That just got dismissed on paper.
Correct. They served a notice in pursuant to the rule that was effective upon service.
Even if the trial court accepts that there's this quote-unquote settlement, there's no evidence of the terms.
Exactly.
And the bank, it seems to me, is in the best position to present evidence that if there was a settlement, it took care of the issue of fees and costs.
I agree completely. If there had been a settlement, there's nothing there. Exactly.
Other than this bald statement.
Exactly.
Okay.
Yeah, if there had been a settlement, if there had been some settlement that resolved the entitlement to fees and costs, the bank should present it.
That's the bank's problem.
Exactly. They're opposing the fee and cost motion. That's their position to present whatever evidence in opposition. And so it's our position that once you review the transcript of the hearing, it is apparent that the trial court was persuaded by the unsworn assertions of counsel, and that was the basis for the denial of entitlement, and that denial under Wilson is a departure from the essential requirements of law, because under 1.420, the costs shall be awarded. It's a mandatory language, and so the court should have granted entitlement to costs. And as this court is aware, and as we've addressed a little bit in the briefing, under Fleet,
it is the case but for fees, quote-unquote costs are going to be de minimis.
I would agree. I would agree. There's no record evidence of that, but I think that's very likely given the size of the record.
So what you're looking for is a remand where you can go back and say, Judge, we're entitled to cost under the rule, and then you're going to argue that cost, you're going to start arguing under the mortgage documents, expenses include costs, which include attorney's fees. That's how this is going to shake out if we reversed.
Your crystal ball is excellent.
You changed the batteries.
I'm trying to figure out where we're going.
That's exactly where this is headed.
But Mr. Whistle, here's my concern.
Yes.
Costs are different from attorney's fees. You agree with that?
Generally speaking, that is the rule.
Because the rule that you're relying on only makes reference, Rule 1.420 specifically addresses costs. You agree with that?
I do agree with that.
All right. And so because costs are different from attorney's fees, the question then becomes, what makes you entitled for attorney's fees? You either look for statute or you look at the contract or anything that would justify the award of attorney's fees. You're with me so far?
I do. I am.
Okay. So now what was before us, and it's an issue on appeal, is that we have the mortgage documents provided, the references within those documents. Where are you relying on? Which provision that you're now claiming entitlement to fees?
Well, as of for today, first of all, let me answer the question. It's paragraph 22 of the mortgage. I'll address that specific language that talks about that in just a moment.
All right.
But I wanted to come back around. The sole issue we're asking this court to decide is the entitlement to costs. How costs are defined under Wilson and under Fleet is the second phase of the analysis when we get to quantum. In this, I'm asking this court to do something very simple. I'm asking this court to remand with instructions to the trial court to grant entitlement to costs and have further proceedings on what the quantum of costs will be.
Remind
quantum hearing, that will
me,
be-
in denying entitlement, the trial court did not make any ruling as to whether fees would be included in cost or entitlement to fees. Is that correct?
That appears to be correct in the transcript. The trial court was very succinct in its ruling. It asked a question of bank's counsel, it asked another question of me, and then it simply said denied. I asked for clarification. I said, Your Honor, is the trial court denying entitlement to costs as well? The trial court then asked me what my motion was seeking, and then said the motion is denied in its entirety.
So to follow up with that, has the issue of attorney's fees ever been litigated in the trial court below?
The motion initially asked for attorney's fees and for costs under two different theories. The first theory was there was a reciprocity contract under 57-105, I believe 7, and addressing the language in the mortgage, paragraph 22. Specifically, it says, lenders shall be entitled to collect all expenses incurred in pursuing the remedies provided in this section 22, including but not limited to reasonable attorney's fees and costs of title evidence. Now, it's our position that by defining expenses to include attorney's fees, and again, this really goes beyond the scope of the appeal here, but I do want to address the court's question.
Well, that's what I wanted to find out, is what was presented below and what are the issues before us here? Because there's no question, I think it's been agreed by Appellee, that the hard costs you are entitled to. So then that leads us to the next question. By the court denying your motion, is it your and you filed a motion for fees and a motion for costs, and by the court denying the motion, does it encompass fees and costs or only costs?
I understand your question, and I'm really doing my best to answer it.
All right, sir.
The trial court denied the motion in its entirety. It is our position that as to the 57-105 reciprocity, that issue is not before this court. The sole issue before this court is entitlement to costs. You keep using the phrase hard costs.
Because there's different costs. the cases out there, there is a distinction between costs and attorney's fees.
And I think the Fleet case resolves that, because in Fleet, there was a contract that defined costs. More specifically, it defined the word expenses. It said expenses include attorney's fees. And this court said that that means that once entitlement to costs is found, defining what's included in those costs is a question of contract. That goes to quantum. That issue is whether attorney's fees are included in the cost by the contract has never been decided by the trial court.
So you argued at the motion hearing that there's two alternative theories entitling you to fees. One is that under the reciprocity statute, you're entitled to fees as a prevailing party. You're saying you're not arguing that on appeal, you're only arguing the rule 1.420 that costs should be, so we can forget about that even though it was argued below, you're not arguing it on appeal.
My initial brief was very narrow in scope.
I just want to make sure because...
Yes.
So if
but I think to address your question...
But that's going to go back to the trial court
Exactly.
to come in the back door anyway.
I agree that we're going to be asking the trial court...
I know, if they argued prevailing party, we settled the case. There is no prevailing party. It's a win-win situation, right? We both win. They got a loan modification agreement. As a condition of the loan modification agreement, we agreed to dismiss the foreclosure.
Right.
And you're saying, gotcha, under the rule, we get costs. Even though there was no provision for fees, there was no provision saying we don't have to pay their fees. I'm not sure they even knew there was an attorney involved at the point of the loan modification, so why would they cover the issue of fees?
Oh, they did because we had filed some motions in the court.
Okay, but not an answer. Something else had been filed, so they were on, no, okay, I'm with you.
So
All right.
There's no question the new attorney was involved.
Remind me, what exactly did your motion seek?
Our motion sought entitlement to attorney's fees under reciprocity and costs under 1.420D.
Okay.
And just to make it very, very clear, I'm asking this court to remand with instructions to award costs and consider whatever the contract defines costs.
When you denied
I don't.
the motion, though, you asked for two things. You asked
Correct.
for cost and you asked for attorney's fees.
Yes.
Seems to me he's already decided that you're not entitled to attorney's fees.
He's never reached the question of what the quantum of costs should be.
Well,
Because he denied entitlement to costs. See, he denied the trial court denied under the reciprocity statute.
he denied your motion.
He denied the
Your
motion.
motion sought cost and attorney's fees.
Correct.
So let's go back on my journey.
Yes.
We reverse. You're going to go back and you're going to say, Judge, I want my cost under the rule.
Yes.
And Judge, I also want my attorney's fees as expenses under paragraph 22 of the mortgage.
Correct.
And he's going to say, well, I've already denied this as to the fees.
I think it's important that this court's opinion, which could be very brief, recognize under Fleet that the question of whether attorney's fees as part of costs, as part of the quantum of costs, has not been precluded by the trial court's prior decision. Because the quantum of costs has never been determined by the trial court because it cut off that analysis when it denied entitlement.
Did the judge give the reason why the judge denied the attorney fees?
He did not say, he did
So-
not simply said denied.
Okay, so aren't we required to give a presumption of correctness that the judge denied the attorney fees under both theories, and you're not appealing under theory A, you're only appealing under theory B?
And if you agree with me that theory B was an error, then that goes back to the trial court, and then theory B is still available to us. Because there are two paths to attorney's fees in this one. One has been put by the wayside. The other is still available if
And the one that was put on the wayside is because you decided not to pursue that on appeal.
I agree.
And I'm not going to ask you why, but I assume it doesn't bother you that this could be affected by the lack of pursuing that on a, you had two avenues to win. You only chose Avenue B.
I agree.
The road more traveled. Because you thought it was a slam dunk.
Well, I looked at the Tubbs case that this court issued, and that footnote said that because under similar circumstance, attorney's fees were denied and because there was no prevailing party. But the court did say that costs were properly taxed, and the footnote said the parties didn't raise the issue about whether or not fees could be taxed as costs. And that seemed to me that the court recognized that there were two different theories or two different distinctions. And I understand that was not decided in Tubbs.
No, I think what those cases rely on is if you're proceeding with a fee request pursuant to a contract, what these cases say is simply look at the contract.
Yes.
Look what the contract says, and that contract could then determine as to what needs to be done. But I guess I have difficulty with your proposition that attorney's fees are automatically part of the costs, because those are very distinct. Attorney's fees are separate and apart from costs. Because costs are different, and you are entitled to getting your costs. And so attorney's fees, unless it's actually set forth in a contract, that's a different issue altogether.
I understand the question, and I think the answer is A, the Fleet case resolves that ambiguity by saying that the parties are free to contract for what costs are defined as. And in this case, the parties have done that. So I think that I'm asking this court to remand on entitlement and to make it clear that because the trial court did not reach quantum of costs, it is free to determine whether or not the contract does define costs to include attorney's fees under Fleet. And with that, I'd like to reserve the remaining time for vote.
You got 3.5 minutes.
Good morning, Heather Pesmack from the Appellee. I think the court, hearing the questioning, already understands the major issue here. This is really a request for attorney's fees. This is not about hard costs. This is not about filing fees.
Was there any evidence presented that they had any costs on their side?
There was no evidence of any costs presented.
Was there any argument made, Judge, we've got all kinds of costs here? I mean, I just see this case going away at its infancy where a defendant hardly does anything, but I'm not the trial judge where I can corroborate any of this.
No, I think that's
I don't see anything in the transcript one way or the other.
The trial court did.
Seems like it's all about fees.
I agree with you, Your Honor. I think this is totally about fees. There's no reason to have an appeal on filing costs. This is about.
Well, they didn't file anything. The bank filed it.
That's true.
Okay.
They may have had some
I don't know.
position, court reporter fees. But I do think that the trial court had in front of it the docket reflecting no answer was filed, one motion was filed, no discovery was conducted. I think when you look at cases like Wilson and Fleet, those are cases where there was extensive litigation costs and fees incurred. That's not the case here. The Lexells motion did seek fees under two avenues. We've already discussed that. And in their motion and in the trial court argument, opposing counsel argued we're entitled to our fees under the mortgage under paragraph 9. And paragraph 9 gives us the right to attorney's fees under Rule 1.420D. And the trial court had the mortgage in front of it, had that argument in front of it, and understood that the case had been resolved by settlement. That was raised by Deutsche Bank's counsel. It was not contradicted by opposing counsel. It was not challenged in any way. It was avoided to the extent that opposing counsel discussed.
Tell me the difference between the fees in paragraph 9 in the, I guess in the note, and 22 in the mortgage. 22 speaks in terms of expenses, I think.
Paragraph 22 is the acceleration clause that does deal with attorney's fees and defines them as expenses, not costs.
Okay.
In paragraph 9, that's the property preservation paragraph. It basically says the lender can ensure its security in the property by inspection costs or things of that nature. And part of the actions, I believe it defines that actions the lender may take would be to retain an attorney under reasonable rates. It does not discuss costs. It does not define attorney's fees as costs. And that's the issue that opposing counsel raised in front of the trial court. Trial court properly, in its discretion, reviewed the case in front of it. The fact that this was a case that had little to no actual motion practice, no discovery, where the borrowers were receiving a loan modification, and as a result, where the bank was settling the case and determined that in its discretion, which was properly within its rights to do, no fees and costs should be assessed.
But you're the one, not you, the bank is in the best position to make sure that issue doesn't come up as part of the loan modification. If the lawsuit's going to go away as part of that, the bank's in the best position to say everybody bears their own fees and costs. And if you don't do that, why should the judge summarily toss out a motion for fees and costs?
Your Honor, often, for example, in camp loan modifications, the modification can be conditioned on anything. It can be conditioned on both parties waiving their costs and fees. So the bank's in a position of wanting to give the borrowers a loan modification, saying we don't want to continue to litigate you. You're entitled to a modification. We're going to give you a modification, and now we're going to stop suing you. But it's not in a position to put, you must waive your, right to go after attorney's fees from us.
So we don't know that part. I understand the record. Furthest it's got is that, well, Judge, there's been a settlement. That's all the judge knows.
The judge does know there was a settlement and a loan modification, and so the judge understood in this circumstance, with the document in front of him, understanding the type of litigation this was, the amount of litigation that had been occurred, and the argument that, one, we're seeking under prevailing parties, which I think the court properly denied because there is no prevailing party here, and two, we're entitled to a
Well, time out. You said there's no prevailing party. Doesn't the case law follow the rule that there is the party prevails who didn't take the voluntary dismissal?
I think, Your Honor, the case law shows that the courts will often look beyond a voluntary dismissal to determine if there is a substantive prevailing party that's prevailed on a point of law or a point of fact. And in cases where the resolution is by settlement, the courts find that there is no substantive prevailing party.
Did the judge find there's no prevailing party? Well, that was just the argument made by the bank's lawyer, and the judge never really gave a reason.
Well, the judge denied the argument that they were a prevailing party. And the argument was made by opposing counsel, by the Lexells counsel.
Well, we don't have it in the order.
The order itself says deny, but the trial record reflects that argument was made.
Well, I know it was made. I'm just trying to figure out if this case were to be remanded, is prevailing party still on the table? Because if the judge impliedly found by necessity there is no prevailing party, what are we remanding to do? Just award the so-called soft costs?
We would argue that this court should affirm the trial court's decision. The court properly assessed at the time it was supposed to assess costs and fees and determined that the amount of costs and fees, which were in its discretion to determine, should be zero. That is our position.
There's no evidence presented of the cost under the rule presented. There's no dollar amount presented.
There was no dollar amount.
Is there any affidavit or other evidence about fees incurred?
I don't think there was.
And to follow up with that, was that hearing on entitlement to attorney's fees and cost?
It was.
Okay, so with that hearing, that's the first step. And could that maybe account for the fact that there was no affidavit in terms of the actual dollar amount provided?
Yes, I agree with
All right, and you would agree that where the trial court erred, and I think there is that concession with respect to the costs, not attorney's fees, but the costs, because the court should have found that they are entitled to costs, and then later on set a hearing in order to determine what are those costs, whether it's deposition, whether it's any type of filing that's pursuant to those rules.
I agree, Your Honor. The court were to hear just as to amount of hard costs. Yes, at that time, I think it would be appropriate for the Lexells to introduce an application.
Okay, and you've answered Judge LaRosa's question about paragraph 9. I believe you've answered for paragraph 22. Let's look at paragraph 22. That deals with an acceleration clause, correct?
That is correct.
All right, and tell me a little bit more, because counsel is saying that's the basis of the language that they're entitled to those expenses, which includes attorney's fees.
Well, as an initial matter, I would argue that wasn't raised at the trial court level, and it certainly wasn't raised in their initial brief. There wasn't any reference to paragraph 22 in either his motion, the trial court record, or his initial brief.
So basically, they did not preserve that argument.
We would argue that argument is waived. in addition, that argument, or that paragraph does talk about acceleration. It does state that expenses, which are defined differently throughout the mortgage, I think that's important to point out. There's different definitions of expenses and costs throughout the mortgage in different provisions, like paragraph 9, which we just discussed, and paragraph 22. Expenses are defined as, in part, including reasonable attorney's fees and title search costs, which are not litigation costs necessarily.
Well, in paragraph 9, those are that's a property preservation. So the attorney's fees are those incurred in property preservation activities?
It says the lender may take acts including retaining an attorney and incurring reasonable attorney expenses for property preservation purposes, and that amount is added to the debt. It does not discuss litigation costs.
And you're saying that is not broad enough to encompass the foreclosure litigation?
I am saying that under the case law that we've been discussing, Wilson and Sleeve, Wilson in particular specifically says the contract specifically and unambiguously has to state that the parties agree that litigation costs should include attorney's fees, and I don't believe that paragraph 9 does state that.
So
Certainly not unambiguous.
So only paragraph 22, the acceleration clause, you would say at best, that's the source of a attorney fee provision for the Lexells?
I would say that is the argument they are trying to make. That would be under a prevailing party analysis. That's often the provision that parties will point to is paragraph 22. But again, the contract at issue is not unambiguous. I think in the Wilson case and the Fleet case, we're talking about one paragraph that is clear that the parties agreed on, not multiple paragraphs defining costs and fees differently pursuant to the substance of each provision, and defining them differently, and in no part of the mortgage are litigation costs defined as attorney's fees. It's just not there. The Wilson case is very specific. We agree to pay litigation costs, including reasonable attorney's fees. That is just not present anywhere in the mortgage. To the extent attorney's fees and costs are discussed, they're always discussed separately as distinct.
It's in paragraph 22, though.
Yes, well, those reasonable attorney's fees in paragraph 22, that is correct.
Why don't we just say the judge erred in denying cost, send it back, and let the trial court figure out what cost really means?
Well, we oppose any attempt to through a backdoor channel, ask Deutsche to pay additional attorney's fees in this matter where it was voluntarily dismissed pursuant to a settlement agreement in which the borrowers got a loan modification.
You said pay additional attorney fees. What's the word additional? That implies the bank paid some to begin with?
They're paying their attorney's fees, but we're incurring all of these expenses, appellate expenses, in something that is just it's upsetting.
Well, what they're saying is the bank had two ways it could have gone. They could have filed a notice of settlement, which would have been a lot cleaner and would have fleshed out these issues and included it in the settlement agreement, or they do this voluntary dismissal. Okay, the case is done. Maybe lulled into a false sense of security. I don't know. But he's saying as a result of that, the case, this Wilson case allows them to come out and say, hey, we want some fees out of this. And we're entitled to it as a matter of law, is what they're saying. If it's in the mortgage documents, we become a prevailing party, and under this Wilson case, we're a prevailing party right off the bat, at least for costs. And then you go to the documents to determine what costs include, and you just acknowledge paragraph 22 does make reference to reasonable attorney fees. Whether it's reasonable to ask for fees when you don't do anything, I don't know, but maybe they did do something that's appropriate to be paid for.
I think Wilson does say under a voluntary dismissal you are entitled to costs, but I would argue that the mortgage at issue here in paragraph 22 does not define fees as costs. It doesn't. It does not just say.
You're saying it's limited to the title insurance?
That's the paragraph the banks always rely on in seeking fees in foreclosure action.
I'm sorry.
What's the provision that the banks always seek to invoke to get attorney's fees in a foreclosure action? It's paragraph 22.
Is sometimes used, yes.
Always used.
But they're seeking their attorney's fees.
And but
They're
because
not
of
seeking their hard costs.
But by reciprocity, the defendant in the foreclosure action is able to rely on paragraph 22.
I agree, if they were a prevailing party, but they're not a prevailing party here. And that prevailing party analysis is under 57105, which we've already discussed is not on the table here. We're talking about a case where the borrower's got a loan modification, little litigation was done, little expenses were incurred. The bank reviewed them for a modification, said you're qualified and we're going to give it to you and we're not going to continue this litigation.
I know, but you're arguing as if we're the trial court. You're making some equitable arguments that the judge...
The trial court in its discretion can consider those arguments, including the 1.420D argument, which opposing counsel argued pursuant to paragraph 9 he wasn't entitled to. And the trial court, in its discretion, rightly denied that entitlement because paragraph 9 does not entitle him to that. The trial court's opinion was not wrong. It should be affirmed as to attorney's fees as costs. Because they argued they were entitled to it under prevailing party, which the court rightly denied, in paragraph 9 of the mortgage. And paragraph 9 of the mortgage does not provide that attorney's fees are included as litigation costs. So the trial court was correct in its decision.
Are you familiar with this VIVOT versus Bank of America case that just came out in June of 2013?
I'm not.
Okay. All right. Well, then we're not going to ask you any questions then.
You know, and to the extent we're talking about Fleet, and I think you're right, we don't really even need to get into it. Fleet was an entirely different case where the voluntary dismissal was as a result of sanctions by the trial court, striking all of their pleadings after extensive litigation. And in Fleet, the bar removed under 57105. And the appellate court upheld the trial court's decision, but that was, the trial court had ruled under 57105. They were entitled to prevailing party fee. And in all of these cases, you know, Fleet relies on Wilson. Wilson relies on Coastal Petroleum, which says the trial court has the discretion to consider which costs are going to be assessed and awarded. Wilson says you don't have the discretion to defer your assessment. You can't defer it to a second trial on this issue, but you do retain your discretion as to the amounts that are due and owing here. And to the extent the trial court denied attorney's fees here under prevailing party and under Rule 1.420D, we believe the court was in its right in using its discretion to deny those fees.
All right. Thank you very much. All right. I'm going to give you 3.5 minutes, like I said.
Thank you. 3 brief points. First, the question arose, did the trial court know that there was a settlement? Then the question is, how did the trial court know there was a settlement? The only way the trial court could have known that was based on the unsworn assertions of the bank's counsel at the entitlement hearing.
But nobody jumps up and says, oh, that's not true, Judge.
I did object to that on page 8 of the transcript. I asserted to the trial court that there's no evidence that the trial court wasn't allowed to rely on that. To the extent the trial court didn't rely on that, it was error. And the Blippi case, for example, says that if there's an objection, unless there's a stipulation, the trial court can't rely on that. The second thing, Your Honor, is the question of prevailing party. Wilson says the prevailing party standard is irrelevant to an entitlement to costs. And I would argue as well that I think it supports the notion that it's irrelevant as to the question of what will eventually be decided by the trial court as to what should be included in costs.
Can I have you just address one brief thing?
Yes.
Preservation.
Yes.
The counsel said you've argued paragraph 9, but never below, you've argued paragraph 22. I want to give you the opportunity to address why is that not preserved.
Thank you. The written motion refers to the mortgage contract as a whole. At hearing, I did refer to paragraph 9. Actually, if you read the transcript, I informed the trial court I wasn't sure which paragraph it was. I thought it was paragraph 9. I was looking for it. And before I had a chance to actually direct the court's attention to the proper paragraph, the trial court denied entitlement. So we never got to the question of which paragraph defined costs as including attorney's fees. The trial court never reached that. So it can't be waived if it hasn't been reached.
But you had the opportunity to argue it.
I'm sorry?
You had the opportunity to argue it.
I can see where you say you misspoke, because you did refer to paragraph 9, and you probably did mean 22.
Right.
But you had the opportunity. You didn't go back for a rehearing and say, oh, by the way, Judge, I meant to say 22.
That's correct. The trial court made its ruling on entitlement before we reached that issue. So the question of what the contract does actually define was never reached. And so, again, it's not waived because it was never reached.
And to follow up, so did you file a motion for rehearing in this case? I'm sure you did.
On a motion for rehearing on a post-judgment case, no. The reason I didn't is because my time to file the appeal was running, and a motion for rehearing on a post-judgment order, I interpreted it not to total time. I didn't expect to be able to get court time before the 30 days ran.
Okay.
So, and in all candor, I don't think I was required to. Maybe
Because
I'm
a
wrong.
motion for a motion for rehearing, the court denies it. You don't know why, the reason why the court denied it. So there was never a follow-up, a motion for rehearing to ask the court what's the basis of the denial, and then to reiterate that you are entitled, basically, to, under paragraph 9 or paragraph 22. Nothing like that was done below.
And that's not required in my, I don't believe it's required in order to preserve the issue for appeal.
The appellate courts are split on that. There's some appellate courts, and I think whether or not we may have weighed on it as to whether or not you need to preserve by filing a motion for rehearing, but that's for another day.
On a post-judgment motion, I don't believe, and I haven't researched that issue very thoroughly, but I believe that's not the case. It was my impression at that time it was not. Again, the entitlement is the sole issue on appeal here. That's
I'll give you an extra 30 seconds to wrap up since we asked you questions. Anything else you want to conclude with?
Just that the sole issue I'm asking you to rule on is entitlement
Okay.
to costs. I'm asking you to remand the trial court for determination of what those costs might be.
All right.
Thank you. Thank you both.
Thanks to both lawyers. Let's move on to the next case. That's going to be Bayless versus State of Florida.